Good morning, and today I get to say happy Friday. It's usually Monday at 10 o'clock that I'm coming to you with a short snippet of legal information. But just like we did in 2019, all through 2020, we are going to be doing one long form Facebook Live every month. And we will advertise as an event what that topic will be. And in January, and given that it's my specialty, I'm focusing on estate planning. So this video will be saved onto the page after we've been live, and you can always go back and look at it later, or tag other people in it at any time. So, I'm sorry I didn't introduce myself properly. My name is Jackie Broman. TBA Law is my business, and I'm an accredited wills and estate specialist. So that means that I did an extra 12-month program with the Law Institute of Victoria and a big exam to be an accredited specialist. And people who aren't, solicitors who aren't accredited can't say that they specialise in a particular area. So I can actually say that yes, it's my specialty. And I went down the path of becoming a specialist in this area for a few reasons. So I've been practicing for maybe 6 or 7 years in general practice, doing a lot of family law, a lot of property, and a lot of everything really. And first I was being worn out by litigation, to be quite honest. I don't think that litigation is rewarding for me. And I was coming across a fair bit of litigation in deceased estates. So after people pass away, the estate had issues. And I believed that a lot of those issues would never have arisen if the estate planning and the will were done correctly in the first place. Then there was also a case that I came across. A friend of mine was acting as a public prosecution at the time, and she was prosecuting a lady who had run a red light and killed a young couple who were crossing the street. This young couple had come down from New South Wales to watch the AFL, and they'd left their 2 young kids at home. They didn't have wills. And so my friend was coming to the sentencing for this lady who killed this couple, and there had been victim impact statements done. And it had been about 18 months that these children had been in and out of family court since their parents had died. They didn't have wills, there was no guardian appointed. So the grandparents, who respectively hated each other, were in family court fighting over with whom and how often the kids would see each other and where they lived and who looked after the money. And I just thought that that is just so wrong. It's not what those parents would have wanted for their children at all. And it's a horrible start to the lives of those children, being orphans and having to walk on eggshells around their respective grandparents and knowing that they don't like each other from the get-go. So there was that case, which I obviously wasn't directly involved with, but it affected me a lot. And then there was another case which I was directly involved with. It was a blended family, and so they had children from their first marriages but no children together. Because it was their second marriage, they'd only just re-bought a house and there was still a fair bit of a mortgage on it. And in fact, the husband had bought the house in his name before he'd met his new wife, so the house was just in his name. And he died suddenly from a heart attack. So they were completely unprepared. He didn't have a will. What he thought was life insurance was in fact accident insurance. So because he didn't die from an accident, he died from a heart attack, the insurance company wouldn't pay out. So there was no money to pay off the mortgage. Now, there was also no will. So there's a new wife as well as the children from the husband from his former marriage. And all of them had an entitlement. Luckily, the laws have changed in Victoria since then, that a spouse now has more protections if their spouse passes away without a will, but they're only protected up to the first 450,000. So back when this happened, his wife was only protected up to the first 100,000, which was not enough for her to keep that house, essentially. So there was a horrible situation where she wasn't earning all that money. She had to refinance a fairly large mortgage anyway and borrow a bit extra to pay kids out. So just tragic. So these are a couple of the cases that have led me down the path of becoming an estate planning specialist. I just think that a lot of litigation and heartache could be avoided if it was done right in the first place. And so today, for the next 20 minutes or so, I'm going to talk about some of the things that should generally, I think, be known, some of the myths that need to be busted, and hopefully we can convince more people to actually do some good planning. So, coming back to intestacy. When someone passes away without a will, they're called intestate, and the laws of intestacy applies. So a lot of people think that everything just goes to the government if someone passes away, which is not correct either. So the laws in each state are different as well. So that can be quite difficult if you have assets in other states as well as Victoria. So if someone passes away and they have a spouse, everything goes to their spouse. That didn't used to be the case, but it's now a new law in Victoria. If someone passes away, but they're a blended family, so they have a spouse and they have children from their first marriage, spouse is entitled to the first $450,000, and the balance after that gets divided 50-50 between the spouse and the children. So you can see that the laws changed to protect the new spouse so that the adult children from the first marriage couldn't jump up and down too much. It doesn't stop them from making a claim on the estate if they have significant need. If there's no spouse and there's only children, everything's divided equally between children under the law. And that includes stepchildren. If there is no children, no spouse, no children, everything goes back to parents. So this is thinking about young kids. So people 18 and over, no spouse, no children, it goes back to their parents. Equally, doesn't matter if they don't have a relationship with one parent or the other, or their parents are separated or whatever. If parents have passed away, so no spouse, no children, no parents left alive, it goes equally to the brothers and sisters of the person who's passed away. So it goes along the same generation. And if any of the brothers and sisters have passed away and they've had kids, it goes down so their kids would get their share that their parent would have had. All right. So there's actually quite a few levels that the laws of intestacy cover. And only if there's no spouse, no children, no parents, no siblings, no nephews and nieces does it go to the government. So the laws of intestacy have improved in some respects, and yes, you can rely on the laws of intestacy for young people if they don't have a spouse or children and they're happy for their parents to get everything equally. The problem is, and I will come to it later, is super. So superannuation is a special type of asset. So most of you would know that we're required to put money into super, or our employers are required to put money into super, and we can't touch it until we're a certain age. It depends what year you're born, depends what type of fund you have. So there's obviously a whole lot of regulation around super. Now, super is not an estate asset. So that means that your will does not cover your super. So what does this mean? So with super, you need to nominate on your super fund who your beneficiary is. You can do a binding nomination. All the super funds have their binding nomination forms on their website. You can only give your super, though, to certain categories of people. Those are a spouse, children, or people who are financially dependent. So that's easy enough for a husband and wife. You'd probably have each other nominated as beneficiaries on your super fund. The problem starts if the husband and wife has kids. So they leave their super direct to each other, but if an accident happens and the two parents pass away at the same time, there's then no binding nomination on the super fund at all, because you can't have a second level of beneficiaries. So they can't say to my spouse first and then to my children. So what happens if you pass away and there's no binding nomination on your super fund? Well, your super fund decides what to do with your super. So they still have boundaries around what they can and can't do with your super, so it won't just disappear. It does need to be paid to someone, but they have complete discretion to decide. They can only pay it, like I said, to spouse, children, or people who are financially dependent on you. So they will contact anyone who's in those categories and ask them to make an application. Those people will make applications and the super fund will make their own decision. You won't get a say in the percentage split. They may not pay it all to your spouse. They might break it up and pay it to some kids. You might have a child that you don't have a relationship anymore and you don't want them to get anything. Well, too bad. If there's no binding nomination, the super fund makes the decision. The fourth category of place where the super fund can pay the money to is into your estate. All right, and so this is a lot of what the estate planning I do involves, to make sure that the super gets to where we want it to go to. Now, in some cases, it's relevant that we pay it into the estate because we're happy for it to come in and for it to go exactly what's happening with the will. So that at least is safe. It's not safe in all cases because if you know there's going to be a claim against your estate, you don't want your super to form part of your estate. So all these factors come in, and this is what I'm thinking about when I'm meeting with clients. The other thing to think about, and this is coming back to young people who don't yet have a spouse and children. So they might start working at 15 and they start putting super away. So it's probably their biggest asset. Super will have an insurance policy on it if it's a industry fund, and that insurance is usually $200,000. So it's worthwhile for these young people to consider their wills, because if they pass away and they have no binding nomination on their super fund, there is no one to pay their super to. They don't have a spouse or children yet. So the super fund has to pay it into the estate. But if they're intestate and they haven't done a will, everything goes equally to their parents. Now that's fine if the kid gets along with both of their parents and there hasn't been a separation between the parents, or they're not speaking to one parent or the other. They can't pay it to their brothers and sisters if they haven't done a will. So when people ask me, when should someone do a will? This is the reason why young people need a will, because they'll have a couple of $100,000 of life insurance on their super fund, and we don't just want that to disappear to the wrong people, all right? So it's a combination of intestacy laws working against you sometimes, and the binding nominations on the super funds just being a nightmare. And one of the other things that super funds don't tell you is that on most industry funds, your nomination expires every 3 years. So of course they're not going to tell you, because they want discretion about what happens. So you do have to do your nomination every 3 years if you want it to be binding. And that's actually something that we're trying in a law reform to get them to fix, but none of this happens quickly. So binding nominations are so important, and we do the binding nominations as part of the process with the estate planning here, because for some people it is their biggest asset. So that's intestacy, what happens when you don't have a will, and we've covered off super, right? So some myths around wills and estates and some funny little rules. So there's no longer a rule that your executor can't be a beneficiary as well, so don't worry about that. There's also no longer a rule anymore that a beneficiary can't witness a will. So they've gotten rid of that law as well. There is a funny little rule that if, and a lot of older parents joke about it, that their kids are going to knock them off quicker to get their inheritance. If someone is responsible for the death of their parent or their spouse, whether it's criminally responsible or not, they are no longer entitled under the will at all. And this is quite interesting in some domestic violence cases, for example, where either the wife has killed the husband out of self-defense, or the husband has killed the wife accidentally through his violence. Their wills leave everything to each other, but unfortunately, because they've caused that death, neither of them are entitled. So you can see how this law would be difficult, particularly where a wife kills the husband out of self-defense. That it wouldn't be fair that she didn't get his estate. But again, these things can be appealed. It obviously doesn't happen very often, although I say that with some difficulty because, there's quite a lot of domestic violence. So anyway, that's an interesting little rule. A couple of other little rules. One is about class clauses. So I use class clauses in my wills all the time, particularly when I'm leaving things to children as a bulk group or grandchildren as a bulk group. So you don't actually have to name everyone, you just use a class clause to define everyone in that class. It's particularly useful for parents who've had a couple of kids and don't know if they're going to have another one or so. So we don't name the children, we just say to my children, so whatever children they have at the time. And same thing with grandparents. If they want to leave a little bit of money to each of their grandchildren, but their kids haven't finished having kids yet, I leave $2,000 to each of my grandchildren who are alive at the time. So that's a class clause, which is interesting. But you do have to be careful because stepchildren and step-grandchildren get pulled into that definition. So if they don't want to include the steps, they have to specifically say not including the stepchildren or grandchildren. And another funny little tool that we use is around gifting. So when you're gifting in a will, you can make a specific gift, which is pretty common, or you can make a general gift, which is really another tactic that we could use as part of the estate planning. So a general gift is, I give my motor vehicle to my sister if I pass away, right? Now, that would be any motor vehicle that I have at the time that I pass away would go to my sister because I've said it's my motor vehicle. If I say in my will instead, I give my sister my Ford Focus, but I pass away and I no longer have a Ford Focus, I have, a Toyota something or other at the time instead, then that gift fails. The other thing you can do is instead of being specific is you can be general. So I can say in my will, I give my sister a red Ferrari. Now I don't own and never will own a red Ferrari, but because in the will I haven't said my, it means that the estate is compelled to go and buy one for my sister. So it's quite an interesting little tool you can use. And you wouldn't use it in the case of a red Ferrari, I just use it because it's a bit of fun. Grandparents sometimes use it, for example, if they want to give a gift to their children that is not cash. For example, they might want to buy shares for their grandchildren and they don't own the shares at the time. So they might say, well, I want to give my grandchildren 500 BHP shares each. They don't own the shares then, but they can compel the estate to buy them. So another little trick that we can use. Now, critical roles in wills and powers of attorney when you're thinking about doing your estate planning. So guardians are really important. We need to be thinking about who is going to look after children. And not only the primary guardians, but also have a backup guardian in there just in case. The other thing when thinking about guardians is, do I nominate a couple as a guardian, or do I nominate the specific person in that couple that I want to be the guardian if something happens to that couple? Because couples divorce. So, for example, would I nominate my best friend and her husband as the guardians for my children? Well, no, because if they separated, I want my best friend looking after the children, not them being a joint responsibility. But the other thing to think about as well is, would I really want my children going through a divorce? Well, no. So then you have a backup guardian to say, if my friend is unable or unwilling, or if they go through such and such a scenario, then it goes to the backup. So we can do all that. Executors, really, really important. Firstly, you need someone that you trust. They're compelled to do what's in the will anyway. It's under the law, they have to. But we've got to think about the family dynamic. And so this is what we do in estate planning as well. We really dive into some of the personalities of the children and how they interact with each other, because we don't necessarily want issues where someone doesn't have control, so they start causing problems for other people. So you can have up to 4 executors. Better to have all the children in as executors if you can. Give them all the power, and then if they decide not to act as an executor, that's their choice. At least they can't jump up and down saying, well, I wasn't an executor, so what are you doing? You need to tell me every step of the way, and it can just be a nightmare. If you have young children, you need at least 2 executors, at least, because they are going to be looking after the funds for your children until your children are old enough to get those funds. So 2 executors, one of them can be the guardian, but I usually say have an independent executor as well, because you don't want your guardian having a conflict of interest with managing the money too, and just dipping into the money willy-nilly without someone independent there. So 2 executors at least. You can have up to 4. Guardians are important. Powers of attorney are important too. So the people you appoint as your attorneys under the powers of attorney, I generally say should be the same people as your executors for your financial power of attorney. The reason for that is because if the power of attorney is triggered, then you're obviously sick, had an accident, unwell, can't do things for yourself. So you're going to want some consistency, and having those people be the same people who end up managing your estate. What else? Claims against estates. So this is usually a really sticky question that a lot of people want to ask about. There is no 100% way of having a completely watertight will. The reason we're able to have claims in Victoria is because we also have testamentary freedom, which is a right that we should be grateful that we have. And in the whole of Australia, in fact, we have testamentary freedom. So that means we can do whatever we want with our assets, right? In some countries, they don't. So some countries have laws as to what happens to people's estates after they pass away. Some countries have partial testamentary freedom. So they say, it might say that a certain percentage of the estate has to go to the government, or a certain percentage has to go to a spouse or the firstborn son. And then after that, you're able to do what you want. But in Australia, we can do whatever we want. However, the law says because we're able to do whatever we want, there are people we have obligations to in our life. And if we don't meet our obligations, then the law can step in and change your will, essentially. So we have an obligation to our spouse and our children, and to anyone who's financially dependent on us. So in Victoria, the law changed in 2015, and those are the categories of people who can make a claim against your estate if you haven't provided sufficiently for them. It used to be open slather on wills in Victoria, so even if someone had helped someone out and they thought, well, I should get a gift for helping someone out, they could make a claim. But that's been wound right back because it just got way too overboard. So now it's really spouse, children, financially dependent people can make claims against estates. So they can, like I said, make a claim if you haven't provided sufficiently for them. So then it comes down to looking at their circumstances, looking at the circumstance of the other beneficiaries, looking at their future needs, looking at their health, and looking at the wishes of the person who passed away. Because if they've considered all this and still thought to leave that person out because of horrible behaviour or a poor relationship, then those factors will come into play as well. So, having said all that there's no way to have a completely watertight will, in estate planning, there are some interesting things we can do with assets so that they don't become part of the will, so they're not part of a claim as well. So this is why it's really important to do your estate planning, particularly as early as possible. So people can use joint assets, they can utilise trusts, they can utilise all sorts of other estate planning tools that we have other than a will to make sure that assets get where you want them to go without having to rely on a will. Because the other thing about a will is it becomes a public document too. So after you pass away and it gets submitted to the Supreme Court for probate, anyone can look at it. So, certain people might want to keep certain things private. So you don't necessarily want everything aired in a will. So this is some of the important work that we do behind the scenes, particularly with farmers. So farmers still at least have a lot of stamp duty exemptions in transferring land, whereas that's been really wound back on other land holders. So unfortunately, we don't have as much room to move with estate planning. But having said that, if you can save your estate a couple of $100,000 by moving some land while you're alive, and you have to pay stamp duty of $10,000 at the time, you weigh up the risk of that. You've saved the estate $200,000 by paying $10,000 up front. So, for some people it's worth it. So, there you go. I've sort of ranted on for a fair while, but I hope that's useful, and I hope I haven't spoken too quickly. But obviously, as a recorded video, you can pause it and go back and check what I've said. And by all means, reach out via the website or direct message me through Facebook, so you can ask any questions that you have. So hopefully that's also given you a better understanding of the estate planning process and what we're thinking about when we're doing it. That realistically, there is no such thing as a simple will anymore, because there are so many factors that we have going on in our heads to make sure that what you want done happens. Now, in terms of the process itself, it takes 2 appointments with us. The first appointment can be on the phone, so that makes it easy. You only have to come in to see us once. And you come in to sign the documents because we need originals signed and witnessed. So after the first appointment, where we gather all the information from you, we'll then email drafts to you before the second appointment. So we have everything ready to go for the second appointment. In preparing for your first appointment, don't think that you have to come in with a whole big financial plan or anything like that. All we really need from you are the full names and addresses of people in the family tree, and we need you to have a bit of an understanding of what you own. We don't need to know amounts, we don't need to know bank accounts. We just need to know, oh yeah, I own this property jointly, or I own this property just in my name. I have my bank accounts at the NAB, or I have my bank accounts at Westpac. I have some savings in Ubank. All these things, that's all you really need. And we can work through it all. If there's anything important that comes up during the first meeting, we can deal with that in the interim before the second meeting. So no issues if there's something that has been missed, like a self-managed super fund or a family trust. We can contact your accountant, get the details from them, and make sure all of that is included. So there you go. Like I said, rattled on and spoke a bit too quickly for that whole time, but I hope that that's helpful. I hope that some of the things you've learned might be something you can speak to someone else about, that you've picked up some tips about the importance of estate planning for certain people, young people with super, young families with young children needing guardians, what I call the sandwich generation, is that generation who are starting to look to retire themselves. They've got adult children and young grandchildren, but they've probably got elderly parents as well. So those people want to be thinking about their parents' estate planning to make sure that they're not dumped with a mess. And also thinking about their kids' estate planning, because they want to make sure that their grandkids are taken care of. So all these things, and I think that it's still about only 50% of adults in Australia actually have a will, which I think is frankly irresponsible in some respects, because it's not hard to do. You only have to do it every 5 to 10 years. And look, to be honest, sometimes the will can be so broad that it can last 30 or 40 years. So realistically, it's just a matter of doing it right the first time, and then making sure you review it if there are major changes. So I'll get off my soapbox now. This video will be posted to the page, so you can go back and look at it again. You can tag anyone's name on it if you think that it's something important that they need to see. And throughout this year, like I said, every month we'll do a long form Facebook Live like this once a month, where we're giving a whole lot more information, a bit more like a presentation or a webinar. I'll still do my short legal tips on a Monday at 10, so those legal tips are usually only 5 to 10 minutes long. But yeah, look out for the Facebook events that we post, where we say what the next Facebook Live topic will be for the month. Other than that, I hope you have a really great Friday. I hope you have a really great weekend, and let's stay safe in the fire season as well. Thank you.